Please, court, counsel. Ladies and gentlemen, I too want to take you back to where I are. I want you to remember that important part that we put you in, because we, both sides, put you in the exact spot that you are right now. We tried to give you a hypothetical to get you as close to this situation as you could be. And why is that? Because you've just heard a lot of argument and all focused on the crime. But if you remember, what we talked about is you have to press the reset button. You have to start over. You can consider it, but you start over. The law is not about revenge. We talked about that. Also, the law is not requiring at this point excuses. We talked to you about that. We said this is not a situation where you could ever excuse the death of someone. I think you all remember that. It was important that we put you in that place. We put you, each one of you, in that place so that you would see the difficult situation you were in and realize it's important to reset your mind. Because the law is not about revenge. The law is about looking and answering two questions. That is how you get to the decision in this case. Okay? Now, the other thing that the law says is the law, what? The law presumes a life sentence. How do we know that? We talk about the fact that if someone is not being sought for death and they're found guilty of capital murder, they are where we are right now. They are being punished. Okay? They are getting a life sentence without the possibility of parole. You know that. Don't forget that, because the argument seems to be that he's getting away scot-free. That's not it. He is found guilty. He will never spend a single day outside of a prison system. Never. The law presumes life. We also talked about that each one of you, every single one of you have the power of one. We talked to you about the fact that if you didn't know that you had that power, you wouldn't be able to exercise it. You remember what that power was? It requires a unanimous decision. The power of one. You each hold that. It's important to remember that. We also talked about the fact that you, each and every one of you, would stand and hold by your decision. If you came to your own personal moral decision, you vowed that you would stand by it, and you vowed that you would respect the personal moral decision of all the jurors. That's where we are. Okay? That's where we are at this point. Then we look at, and we talked about the special issues. Special issue number 1. I'll read it to you with my glasses. It says, do you find from the evidence beyond a reasonable doubt that there is a probability that the defendant, Kristopher Love, would commit criminal acts of violence that would constitute a continuing threat to society? When we went through there, we talked about who has the burden of proof. Burden of proof rests upon them. They have to prove it to you. And how do they prove it to you? They have to prove it to you beyond a reasonable doubt. That's the burden. The burden never rests with us. We talked about it many times, that we have no burden whatsoever to put on any evidence, cross-examine any witnesses. That burden rests upon them. Importantly, in that first special issue, we talked about the definition of probability. Lots of people gave their versions of what it was, but we told you there's not a legal definition. But what we had heard was that it's more likely than not. We gave you the example of a lottery ticket. You bought a lottery ticket. Is it possible that you could win? Well, sure, it's possible. Is it probable? And I want you to pay attention to that word, because that word, as we focused on, is very important. Because if you recall all of the questions from the prosecutor in regards to the warden, they used the word possibility. Why would you use that? It's not relevant to the decision that you all are making here. That's what you're looking at, the law. You need to follow the law and how you were instructed about the law and what's in the charge. This is all in the charge. I talked to you about the fact it has to be unanimous. If you look on the second page, it says under special issue number 1, you may not answer special issue number 1 yes unless the jury agrees unanimously. The law, that's what you're focusing on at this point, not to focus on revenge. That's not what it's about. We then went into the special issue number 2. Special issue number 2 sets out, do you find, taking into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, Kristopher Love, that there is a sufficient mitigating circumstance or circumstances to warrant a sentence of life imprisonment without parole rather than death sentence be imposed? We focused on those words. We focused on circumstance or circumstances. We indicated to you, first off, what might be mitigating to one doesn't have to be mitigating to someone else. All of you can decide what is mitigating to yourself. We also talked about the fact that it's not a circumstance. It could be one circumstance. If there was one that rose to the level that was sufficient for you, that's all. However, we also said it could be a number of little sufficient mitigating circumstances that, if compiled together, would warrant that a life sentence be given. Ultimately, we also talked about fairness. We gave you an example in the grand jury, in the court ire, about if you had two capital murders, one was in Denton County and one was in Dallas County, and what was the fairness about seeking death on one and not seeking on the other. And that was something we talked about that you can consider in determining a death sentence or a life sentence. We also talked about mercy. We talked about the fact that mercy alone is sufficient. You've heard lots of evidence in here, lots of it, and we believe that evidence points you in only one direction. If you follow the law and go through the questions as proposed to you, reset as was required of you, there's only one result to you, and that's for a life sentence.